This is Emory JV, and both sides will have an opportunity to present their arguments to the court. The appellant may have 15 minutes and will also have the right to take up to 5 minutes for rebuttal. And then the appellee will have the full 15 minutes. And the court has read the briefs and is prepared to hear oral arguments. Would you like to reserve any time?
Yes, Your Honor, I would reserve 5 minutes of my time for rebuttal.
That's absolutely fine. Thank you. Oh, please don't mention any names of any of the children or anything. Thank you.
Thank you. Good morning. May it please the court, Attorney Corinne Hoover-Six on behalf of the appellants, whom I will refer to as the Matheny's. All of the assignments of error alleged on our behalf relate to one big picture issue, and that is, in an abuse, neglect, and dependency case, after a child has been found to be dependent and placed in the legal custody of a third party, what, if any, consideration to the biological parent's paramount rights should be considered by the trial court in subsequent modification of custody proceedings? Here, the trial court found that in this situation, the best interest of the child was substantially subservient to the paramount rights of the biological parents. We asked this court to reverse. The facts of this case were that a child was born in 2018 and removed from mother at the time of birth. That child was adjudicated to be a dependent child. No father came forward to establish paternity, and no alleged father was otherwise determined to be the biological father of the child at that time. That child was placed in foster care with my clients, the Matheny's. Then, the case ultimately resolved and was closed by a grant of legal custody to relatives of the child. For the following year, the relatives of the child exercised their care, custody, and control of the child as legal custodians by making all decisions related to the child, including to delegate day-to-day care of the child to the Matheny's. The relatives continued to make medical decisions, visitation decisions, and allowed my clients essentially to share in that, and they parented this child essentially conjointly.
Counsel, can I interrupt for a
Yes,
minute?
of course.
You said that very eloquently, but you said it like it's a good thing. The delegation of care of the child to the Matheny's. I'm struggling with that, and I believe the trial court did also. I'm going to address that issue as it pertains to your clients.
Yeah, so as it pertains to my clients, certainly their position is that it was a good thing for the relatives who received custody to delegate care because this child had been severely bonded to the Matheny's. The child had been there for 5 months out of its life initially, and then thereafter, from that 5-month mark until about a year later when custody was resolved, continued to have this bond to the Matheny's. The Matheny's continued to care for the child. So there was no issue where it was transferred to the relatives and then back to my clients. It was that this child had known them, and then was approximately slightly over 1 year old, I believe, when my clients, when the relatives were granted custody. So the relatives at that point said this child's been here for a year, this child has a substantial bond to the Matheny's, and they believe that was in the best interest of the child for that bond to continue. After that, then after a year of raising this child essentially conjointly, the relatives and the Matheny's decided that it should be the same person making the decisions for the child as having the day-to-day care. They believed altogether that that was what would be ultimately in the best interest of the child moving forward. At that time, my clients filed a motion to transfer custody to them, and the relatives supported that. Of course,
Now, what was the motion actually to transfer custody, or was the motion for just legal custody of the child?
It was motion for legal custody, but essentially, I think in all intents and purposes, it was the same thing. It was asking to transfer the child and the legal custody of the relatives to our clients. But the motion was certainly captioned in motion for legal custody.
And at the same time, then the parents were
Yes, and so at the same time, the parents who had really very minimal involvement stepped forward and then they asked for custody as well. Following the trial, the court found that the paramount rights of the parents should come in front of the best interest of the child, despite the fact that the professionals involved, including Children's Services and the child's guardian ad litem, said it would be in the child's best interest to be placed in the Matheny's custody.
Counsel, let me stop you. This is an unusual case, and I find it fascinating. Unfortunately, it's very sad because it involves real people, but I think the issue of law is very fascinating. But I'm wondering, isn't there a presumption, or I should say, the whole point of the law in regard to, when you are taking away the rights of the parents, the termination of parental rights, the law is based on the fact that the child, it's always in the best interest of the child to be with their biological parents. Then from there you go.
Yes.
So what happens to that when the parents then file for legal custody? Because you're saying, that basically the child's rights take over, that the best interest, with the child is paramount there.
I agree with you, it's a fascinating issue, and I think that the real significant difference is that once a custody transfer has been made from biological parents to a third party, that right there severs those parents' paramount rights. And I believe there's 3 cases from the Ohio Supreme Court that support my position on
Now,
that.
let me just interrupt you. So you're saying at that point, then it overcomes basically the presumption that a child,
Yes.
it's always in the best interest of a child to be with the biological parents.
Yes, after an initial award of custody to somebody else, paramount rights then become subservient to the best interest. The 3 cases I believe support our position when taken together are 3 different cases from the Ohio Supreme Court. The Macito case states that suitable parents have a paramount right to custody, care, and control of a child, but once an award of custody is made to someone else, the standard for modification is the best interest. The Ohio Supreme Court further, in Ray Hockstock, indicated that once a finding of unsuitability, parents then lose their paramount rights of custody and control, and that any modification must be made pursuant to 3109, which is interestingly the domestic relations statute setting forth the best interest of the child. The third Ohio Supreme Court case that we believe supports our position is N. Ray Perales, which defines unsuitability, which includes an adjudication of dependency. So taken together, we have this situation where the child was adjudicated dependent, therefore finding the parents to be unsuitable as a matter of law, and that therefore after that unsuitability determination was made in 2019 when the relatives were granted custody, that the paramount rights of the parents were severed then, so that the modification standard should have been only the best interest of the child.
Let me ask you this. It sounds like with your theory that if legal custody is granted to somebody else, another relative or a non-relative, non-relative, as in the case here that they're wanting to be granted custody, that a parent would never be able really to get their child back, right? Because you have to show the change of circumstances, and then you look at the best interest of the child. When is it ever going to be in the best interest of the child to remove them from somebody that's cared for them for the last year or 2?
I think the difference would have been had parents been more intricately involved during this time. So if these parents had been visiting, often, they had established a bond with this child. They had weekly contact with the child. They were involved in things like, when the child was sick. I think all of those things would make a big difference in this case. But none of those things occurred. These parents were marginally involved and visited, I think, a handful of times during this year. So this child essentially had no real relationship with that.
Of course, the allegation is that was orchestrated, that the Matheny's orchestrated that in order to have a better bond with the child and have the best interest and be able to adopt the child eventually.
I think the allegation was that the relatives did that. So interestingly, at the initial award of custody, when the relatives were granted custody, my clients were certainly involved. They were not a party to that proceeding. They were not sitting in that court. They had attended other hearings with all other parties, but for whatever reason, and certainly I wasn't representing them at the time the initial custody award was made, only the relatives showed up. And so the relatives are saying, are making these affirmations under oath as far as they're caring for the child. So any allegation of fraud, I think that there's a big difference is that my clients were not the ones that showed up and appeared in front of the court and, said something was happening that didn't. And the Starchers were the ones, the relatives were the ones in control of visitation between the child and the parents. So as far as that goes, I would certainly ask this court that if anybody was involved in any fraud or any pushing out of the parents, that it not be imputed to my clients who had no legal authority to do that. If anything, it should be imputed to the legal custodians.
You have just about 12 seconds before you go into your rebuttal.
Thank you. I would reserve the remainder of my time.
Thank you. Great, Mr. Lowry, you have
Thank you,
15
Ron.
minutes.
Yeah, Dave Lowry for father, James Bryce. One reason why I showed up today was to wish Judge Callahan luck.
Oh,
Everybody else bailed on me, but she's always been very professional, and I respect that.
I was going to say you're going to make me cry
So
too.
with that, I wish you the best of luck.
Thank you.
Dave Lowry for Attorney Bryce. I'm confused by Appellate's argument, quite frankly. The test in a case like this is a so-called DN mod. If you remember, I was here about 3 months ago before you. I had a little bit different case. I had a case where mom had completed all of her case plan objectives, and my argument at that time was based upon her completing all the case plan objectives and getting back the child, then that reset that concept of a finding of unsuitability inherent in a DN, a dependency neglect case. And the court shot me down because there were some issues with the magistrate that wasn't argued at the lower level or whatever. I still think that should be the law. It may or may not be, but I think that should be. This particular case, what confused me about Appellate's argument is the court never really, I don't understand where this paramount right of the parents is coming from. This court was clear that 414 was the correct standard. 2151-414 was the correct standard. And I go through on page 9 and 10, I think I do a pretty good job of talking about in re Perales, Hochstock, and these other Supreme Court cases that have established that in a juvenile court custodial proceeding, that's the correct standard. 310904 is the standard. It says in Perales and these other cases, that's the standard to be used in a a dispute between parents in either a divorce or dissolution or some other type proceeding. I think that's abundantly clear by the case law. But the other reason why I'm confused is, notwithstanding that fact, the court considered 310904, which is the argument of appellate seems to be that they didn't and they should. And if you take a look at the court's findings in this case, the court clearly considered the statutory factors in 04, but in the statutory best interest factors, the court specifically alluded to 310904 in paragraph number 2, in paragraph number 5, in paragraph 6, in paragraph 7. So if the appellate's argument is, gee, the 310904 is the correct standard, the court considered it. So the argument is moot. The court considered 2151-414 as well as 310904, and the court in its where it talks about on page 1 or 2, it talks about the statutory scheme. It talks about 2151-414 being the go-to, with 310904 being a backup for the court, you know, because the law says the court shall consider all relevant factors. And our court here has always characteristically considered that 310904 because there are other factors that can guide the court. And I think that's what the court did. So argument number 1, as well as I believe it's argument number 3, fall on deaf ear with me because the court did that. Appellate also has an argument with respect to the 60B. It's irrelevant because the court didn't even consider the 60B. The court denied and dismissed the 60B motion that was brought forth by some of the appellees because it said it was moot and it wasn't relevant and it wasn't even heard. So let me just go back to the court inquired about what this was, and I argued this in my brief. It was initially filed as a motion for legal custody. It was filed on April 29, 2020. I argued that it was never really proffered in proper fashion under Civil Rules 24 and Civil Rule 7. It was never filed as with a pleading. I think the motion on its face is defective, which is one of the arguments that I raised in my brief. Another one of the issues that I raised in my brief is the question of whether this is ripe for a hearing. As this court will understand and agree, this was a motion for legal custody was granted. However, there was a retention of jurisdiction, and the court retained protective supervision, or PSU. That has not terminated. That still is in effect as of today. There is a hearing, I believe, in a couple weeks or whatever on that issue of protective supervision. But this court, as I understand it, has always been resolute in the understanding that until such time that there is a final appealable order, and I cited a 9th District Court case in my brief that this court has relied on in the past to suggest that as long as there's a retention of protective supervision, that case is not ripe for consideration by the court. So in this particular case, Magistrate Walsh issued an order because there was when he reviewed it and he issued an order, he said that that issue would be held in abeyance pending further ruling, and so I guess that's what we're here for today. Lastly, I don't know how much time I have, but real quick, this case is unusual because I've been around for a long time, not too long, but I have never seen Judge Teodosio suggest that there should be a criminal prosecution out of a legal custody case. That is unheard of. I go to juvenile court a lot. I've never, ever heard a judge our judge refer a case for criminal prosecution in a dependency neglect case.
And I was going to get into that. When you're reciting all the things that the court did, it also could be an argument that the court, I don't want to refer to her as she or he or anything else, the court was so appalled by what happened here. And the court said a couple times in the entry that the Starchers had decided they knew better than the court itself in making the determination as to what was in the best interest of the child. So an argument could be made that maybe the court's judgment was a little clouded when it came to the best interest determination as to the court being frustrated with what occurred by the Starchers.
Well, and I don't disagree with you, and I was going to move to that here in a minute, and how the pages are cut off. But if you take a look at large B, I think it's about 3 or 4 pages in, the court addresses that when they say the Mathany's motion for legal custody. The court does indeed say that nor can the court find it is James' best interest to be placed in the legal custody of Mathany's. The Mathany's participated in a deceptive scheme to gain custody of the child. And then the court does go on to consider the 215142 in 09, and the court obviously placed great reliance upon that issue. So I hear what you're saying, and an argument could be made to that effect. But what is clear is the Mathany's, regardless of what counsel says, and the Starchers lied. They perpetrated a fraud upon this court. And, you know, I'll ask you, if you take a look at this April 29th, 2020 motion that's filed by the Mathany's, take a look at the UCJJJ affidavit that's attached to it, if you would. Paragraph number 1, where the child has lived, okay? This is a flat-out lie, based upon the evidence that was set forth at this hearing. The Mathany's represent that from February 1st, 2009 to present, that the child resided with Brandon Starcher and Olivia Murray at 4533 Arlington Road in Uniontown. These people knew that was a lie. That child did not spend a single night at that house. So, Judge, to your point, maybe the judge thought, gee, these people are willing to lie on a UCCJ affidavit to something as significant as where does the child reside. That's a flat-out lie. So counsel can get up here and dance around how involved the Mathany's and or the Starchers were, but these people clearly, this is all I need. This is fraudulent. This is not the case. So does the judge not sit there and say, and she says in her order or her decision, she says, gee, how am I ever supposed to believe these people? How are we supposed to trust these people? You know, you take that coupled with, everybody knows children were getting money at this time. You know, the Starchers admitted that they got money under these various federal programs. It was never given to the Matheny's. That's the kind of people that are involved in this case.
But of course, that's the Starchers.
That's the Starchers. But
Then argument is made that it's ambiguous because the child did legally reside with the Starchers during that time period, because that's where the legal residence was.
to me, that argument is so ridiculous that you know, okay, that's fine. You know, I mean, if that was the case, I'd be scared to death where kids were really living. I mean, the whole point is when you have legal custody, you know, you sign a statement of understanding, you know, the child, I'm going to take care of the child. I'm going to take care of the child till the child is emancipated or 18. I'm going to do this. I'm going to do that. I mean, if we say that, okay, for the purpose of legal custody, you've got legal custody, but this child can live anywhere they want or reside anywhere they want, that, in my opinion, is an incredible perversion of the law, and I can't even fathom that, that any court would adhere or adopt or even acknowledge that concept. I mean, that's just not, that's not the way, I mean, that's just not the way, in my opinion, the statutory scheme or the law of the state of Ohio should be ever, quite frankly. So with that said, I appreciate your assistance, Judge. Good luck. And you'll be okay. You'll be, thank you.
She'll be okay, whether the rest
She'll
of us
be
are,
okay.
that's another question. All right, thank you very much for your argument.
Yeah, thank you.
And you have 5 minutes.
Thank you. In response to Attorney Lowry's argument that with a DN, a dependency modification, if a parent completes a case plan, it should reset their parental rights. I will note that there is no case law anywhere that supports this position. Instead, the cases that I have outlined to this court, set forth by the Ohio Supreme Court, say the opposite. The opposite is that once a finding of parental unsuitability has been made, the game changes. In regards to this 3109, which is the best interest factors under the domestic relations statute, it is very interesting, and I do agree that traditionally, if you look at 3109 on its face, it is the domestic relations statute. However, case law has indicated that those factors apply in a modification proceeding, including in juvenile court. And the case that does that is Henry Huckstock. That case indicates that after an original award of custody has made, that award can only be modified in consideration of the 310904 factors. And so I think it's very different. In a first determination, should the juvenile court be applying the best interest factors of 3109? Absolutely not. They have their own best interest factors in 2151 at the initial case. However, after that case has been resolved, and it was resolved here with a grant of custody to the Starchers, then the modification standard is the 310904 from the domestic relations statute. So it certainly applies, and there is a big distinguishment there between a first-time proceeding and a modification proceeding.
I know you have stuff that you want to go over, but I just wanted to ask you if you would reply a little bit to his final couple of order argument.
Yes, very much so. Thank you, Your Honor. So there's several cases on point to this, one of which is that if protective supervision is maintained and the child's ultimate custodial option is still in flux, it would not be a final appealable order. This is very different. The courts transfer custody, took a child out of the home of the Matheny's and out of the legal care custody control of the Starchers and put this child in the home of the parents. So, you know, to our understanding, that affects their substantial right in so much that the Matheny's, essentially their entire case was decided really definitively. And the Starchers were then deprived of their ability to exercise care, custody, and control. The other aspect of that, as far as the protective supervision, I would just agree with Attorney Lowry. Protective supervision has since been terminated. And so this child, there is, although at the very first time of the appeal, protective supervision was maintained, the court in their entry indicated protective supervision was merely for the transitional period to essentially make sure this child was okay after being moved from the only home it had ever known to the parents. So the court, in their own words, says it's for transitional purposes. I think that the trial court acknowledged essentially that that was a final order, that they were not going to revisit that at any point
So
in time.
has the council, has the child been fully integrated back into mother's home?
From my understanding, yes. Yes. And then the second issue, as far as the final appealable order status on that, that should this court determine it was not a final appealable order, which certainly is within your discretion, we will be right back here on the same issue, of course, in the future. And what I would ask the court is a consideration of there's a child here, and certainly this child has been through quite a lot. So if the court determines it's not a final appealable order and we're back here, all that serves is to essentially prolong the unrest of this case. So I would ask the court to definitively determine it as a final appealable order for that purpose. I will touch just briefly on this allegation as far as the Matheny's perpetrating a lie. And Your Honor, Judge Carr, you hit the nail exactly on the head as far as my client's position. They testified that they listed the child's address on the UCCJA affidavit because it was their understanding it was legal residence. The child on all forms, anything that mattered, had been listed as their residence. Doctor's forms, benefits that the Starchers applied for. Starchers claimed the child on taxes. All of those things as far as legal residence were the Starchers, and so my clients were under the impression that that was the child's legal address. Lastly, as far as this allegation that you cannot have legal authority and delegate that to somebody else, and that would subvert this statement of legal understanding, I would note that that's exactly within the realm of the law as it pertains to guardianship proceedings. Is that guardianship proceedings in probate court?
You're running out of time.
Thank you. I rest. Thank you, Your Honors.
Thank you so much. We appreciate your arguments today, and the court will take the matter under advisement and will issue a written opinion, as you both know, and that will be sent to you, as well as we release online as well. So again, thank you for your arguments. I have to get used to being back in person, and so it's nice seeing you both, and I wish you a good day.